Take number 400. I'm having a very hard time making this video. My name is Vincent Maletti, and I am the founder, owner, partner of Maletti Law. You can find us on our website, www.malettilaw.com, www.malettilaw.com. Click the subscribe button below on YouTube, on the channel here. Subscribe to the page, get infos and updates all the time. I need to make this quickly because I've now made this video 47 times and I can't seem to get this right. The name of this video, very quickly, is called Restrictive Covenants Made Easy. This question has come up internally many times, has come up with my clients. They want to hire somebody has a non-compete clause, or they want to institute a non-compete clause in their company, or they want to, with vendors, they want to non-compete with their vendors, whatever the case is. Many people want non-competes because why? Because we're becoming more competitive as a society. Society is becoming broader and broader and broader. We're finding services are overlapping greatly. Techniques, as society continues to develop, as the economy continues to develop, techniques are becoming more narrow. It's not as obviously, creativity should never stifle, but companies do have, obviously great ideas, tend over time to not be as abundant, let's say, because people's always, I always think back to the episode of South Park, Simpsons did it, and somebody was, the whole concept of South Park was that the Simpsons have been around for 4,000 years as a cartoon, South Park maybe 10 years, and everything South Park does, the Simpsons have already done prior. So I guess Matt Stone and Trey Parker, the founders, decided they were going to make a joke, make an episode making fun out of that. All right, I digress. So listen, restrictive covenants, right? Very broadly overall, restrictive means you're not doing something. Covenant means a contract, right? Covenant, think of property, covenant of size, and think of the Bible. Covenants, the covenants in the Torah, So a covenant is a promise not to do something. A covenant is a promise, and a restrictive covenant is a covenant where you restrict, where you promise not to do something, okay? So started in common law at some point down the road as it becomes more and more common. So started in common law, as it becomes more and more common, it's now become contract law. And contract law, keep something in mind when it comes to contracts. Contracts really means private law between the parties, right? Parties agree to make these laws amongst themselves, they sign to it, and realistically, that's what contract law is. So a lot of people don't seem to make that connection. You just have this body of contract out there, and that's what it is. There are restatements of contract, but contract law is really the rule of law, or rules established between parties that they both sign on to, they both agree to, and it becomes law between those parties, right? So, okay, so we have the source, right? The source was once common law, now it's contract. What are the 5 things you really need to focus on in order for these things to become enforceable? The 5 things we need to focus on: 1, they must be reasonable in time; 2, they must be reasonable in scope; 3, they must be necessary to protect the legitimate interest of the employer; 4, it must not unreasonably burden the employee; and 5, it must not be harmful to the general public. So remember those 5 pieces. It must be reasonable in time, it must be reasonable in scope, it must be necessary to protect the legitimate interests of an employer, it must not unnecessarily burden the employee, and it must not be harmful to the general public. Okay, so those are 5 interests that we need to pay attention to. So let's kind of just go through them real quickly, make this video somewhat fast. All right, so 1, it must be reasonable in time. You cannot have a restriction in place for a bajillion years, okay? So if let's say you work, Vinny Maletti works for an e-commerce company. I work for Amazon. Vinny Maletti works for Amazon. Amazon gives me a non-compete clause. I signed the non-compete clause. The Amazon non-compete clause says I may never work in e-commerce for the rest of my life. That time frame is the rest of my life, out the window. Courts aren't going to enforce that. Generally, anything up to 1 year is presumably reasonable. Anything beyond 1 year, the further you get out for 1 year, the more unreasonable it is. So just keep that in mind. Generally, restrictive covenants up to 1 year, I'll consider reasonable in time. Scope, I mentioned Amazon, right? So Vinny works for Amazon. And Vinny signs the NDA with Amazon. The NDA says I may never work again for any company that sells on e-commerce platforms. Nonsense. That will never be upheld because every company on their planet works on e-commerce platforms at this point. Quite frankly, I've seen vape shops. I've seen underground spas. Everybody has a brick and mortar at this point. If you have a brick and mortar, you have a website. You may only have a website and no brick and mortar, but if you have brick and mortar, you have a website, right? So if your restriction, if the Amazon restriction is any company that has any kind of e-commerce platform, you're restricted, not going to happen, that's out. It has to be reasonable in scope. So it's got to be, let's say if I'm working for a t-shirt company, right, and I don't know, I make t-shirts, and my restrictive covenant is I am not allowed to work for any competitive t-shirt company on e-commerce for the next year. That makes sense, right? That's a reasonable scope, so that's okay. But if it's something to the effect of like, I may not work for any company that makes any fabrics at all in the next 10 years, that's going to be unreasonable based on scope and based on time. So keep that in mind, right? So that's actually combining part 1 and 2, right? So they have to be reasonable in time, have to be reasonable in scope, okay? We're going to come back to the protecting the legitimate interest, just simply because I want to, I want to like do kind of like an order. After that, I want to say it must not unreasonably burden the employee. So specifically, that really has to do with the employee being able to live their lives. If the employee is not able to participate in society as a normal citizen because of the restriction, that's not going to happen. It's going to be washed out. It's going to be tossed. That's not going to be cool. So it's got to be something that doesn't unreasonably burden the employee. Again, it's got to be something that is a restriction, but not terrible, right? So 1 year restriction. Like I mentioned before, maybe only insurance if I work for a shirt company. It's got to be something that's not unreasonably burdensome on the employee to the point where they can't even they don't know, it's impossible for them to perform. Okay, it must not be harmful to the general public. You'll see this a lot. Say like a perfect example, this is like doctors, right? Doctors and nurses. Let's say they have a non-compete that says you're not allowed to work for any other health system in the country. That's a big problem because aside from the fact that A, it's too broad, and C, the time frame is bad, but also it's harmful to the general public. Doctors save lives, nurses save lives. Lawyers, on the other hand, destroy lives. But doctors save lives, nurses save lives, right? So there can't be a terrible restrictive covenant that prohibits them from doing their life-saving functions as a nurse or a doctor, right? So court will look naughty on that. Court will not be happy about that. So now let's go back to the third one I had mentioned, but I wanted to push off. It must be necessary to protect the legitimate interests of the employer. It must be necessary to protect the legitimate interests of the employer. Necessary means that there must not be any other methods that are significantly less restrictive to protect this interest. So that's the term necessary. And also, but what are the interests? Like substantively, what are the interests that needs to be protected, right? So for instance, goodwill and customer relationships. Goodwill is, I have goodwill with you gals and guys listening to me here. I have goodwill with you that are listening to me. You see me, you think I'm an authoritative force, you think I speak with some kind of credibility. I have goodwill, my name has goodwill with anything I deliver on these platforms, right? So I have a certain amount of goodwill. I want to protect that goodwill. I'm allowed to protect the goodwill. That's a legitimate interest, right? So my goodwill, a company's goodwill, is a legitimate interest to protect by the employer. And that's your employee relationships, that's your consumer relationships, basically. Second thing is also another thing that the courts have identified that's a legitimate interest of the employer is preventing disclosure of confidential information and trade secrets. If you have a really good contract in place with the company and the company really goes out of their way to give you a really good price and really good terms, you could protect that. That's something you want to protect because that agreement gives you a competitive advantage over others, and that's something you don't want to disclose to people willingly, right? So you could protect that. Something like that you could protect. Another third thing that courts are very adamant over is the employee services are unique and extraordinary to that company. So let's say Vinny Miletti works for Amazon. Vinny Miletti decided he was going to create this awesome logistics program for Amazon, where it's like this fantastic logistics program, and I am the only one that knows how to use this program, and I use it well, right? Amazon essentially has this. I have been doing this on behalf of Amazon. My work essentially belongs to Amazon. Everything belongs to Amazon. I kind of like everything goes on behalf of them. And because those services are unique and extraordinary, Amazon has a right to protect them. If it's something that like some kind of algorithm that nobody knows or some kind of platform search that nobody knows about, that's a cognizable interest that should be protected. That a place like Amazon would look to protect because it's unique and extraordinary to my position, to Amazon, to what I've done, to my experience and how I did this for the company. So that's generally, those are the three biggest things you see in a courtroom in terms of like what's a legitimate, recognizable interest for an employer to protect but not compete. It's, you know, A, protecting goodwill or customer relationships. B, preventing disclosure of or using confidential consumer information in any kind of trade secrets or any kind of way that's contrary to the interest of the employer. And C is employee services that are considered unique and extraordinary. Those are things that can be protected by the employer. So those are the three legitimate interests of the employer. Going back one more time to the 5 items that should be present in order for it to be enforceable. Remember, item number 1 was it must be reasonable in time. Item number 2, the restriction must be reasonable in scope. Item number 3, the restriction must be necessary to protect a legitimate employer interest. And item number 4 would be that this restriction must not unreasonably burden the employee. It must be like, the yoke must not be that heavy, for another biblical reference. I'm sorry, I keep hearing the term covenant and I keep wanting to cite biblical stuff. So it should be too unreasonably burdensome on the employee. And the 5th item is that whatever you're protecting, that restriction must not be harmful to the general public. So if they're producing something that's great for the general public, then they should be permitted to do so. All right, so that was restrictive covenants made easy. Restrictive covenants made easy. Boom. So that's that video. Like I said before, go to the news, go to the website www.millettilaw.com, www.millettilaw.com. Go subscribe to this channel. There's a YouTube, subscribe to click on that button today. If you need me, obviously I'm here for whatever you need. I'm more than happy to help, more than happy to assist. My staff is more than happy to assist. Just reach out to us. I request, my only request is that you go through the website, because if you go through the website, it's fantastic. You could just punch in your information. I could find you on the radar. Life is beautiful. It'll be on my calendar, and I'll definitely get in touch with you. My admins will get in touch with you if you need, whatever the case is. But you know where we are, and I'm gonna cut it at this. So look, yours and Laws, love and lifts. We wish you all the best. Stay healthy, stay strong, stay safe, and let us know if you have any issues and concerns. I hope this video was helpful. Have a wonderful day.